Why do you keep hitting on people that you claim that you love?
I made a mistake.
No, you didn't make a mistake. You made a choice. When you put your hands on someone, it's not, oops, I mistakenly punch you in the face, or oops, I mistakenly choke you. You're making choices. So I'm trying to figure out what is your problem.
I was just very angry, and I know I shouldn't have done it.
Yeah.
I know it was wrong.
So you have your daughter. How would you like it if she's in a relationship and somebody's putting their hands on her? How would you feel about that? And for them to be saying, oh, it's a mistake. I was angry. Counsel, have you received all the discovery?
Yes, Your Honor, there is, there was a request for CPS records, but they do not share a child. The child was not involved, but I think there had just been a request. We have not received those, but we're okay going forward with that.
All right, the court will find that the state is in compliance with discovery.
Thank you, Your Honor.
All right, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it?
Yes, Your Honor.
And did you sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of assault, family second offense? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Trevino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Absolutely.
Are you a U.S. citizen?
Yes, ma'am.
Excuse me, Mr. Dodson, you all are talking too loud. All right. I'm sorry.
It's okay. You're good. No
Mr.
worries.
Trevino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, ma'am.
And are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, the state is recommending deferred adjudication. They're taking in consideration 2024 CR 6362. County Court Cause number 728-729, 728-793. There's an affirmative finding of family violence. There's to be no contact with Kiana, Kiana Richardson Boycourt, Boicourt, and there's to be restitution in the amount of $500 to the complaining witness. Did you understand that to be the plea?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Counsel, is that the agreement?
Yes, Your Honor, it is.
State, is that the agreement?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No such motions have been filed.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. Did you understand thus was a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
Yes, Your Honor. State would offer states one and attachments.
Any objection?
No objection, Your
All
Honor.
right. And state, have you had a chance to speak with the complainant?
I've let our advocate know to reach out to them, Your Honor. Yes.
All right. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
My client wishes to accept responsibility and move on from this episode. He is no longer with the complainant. They have no contact with each other. There's no children between each other, so it is, that relationship is done.
All right, do you have any children?
Yes,
Yes, ma'am. Yes, ma'am, I do. I have a 3-year-old daughter.
All right. And how often do you see her?
24/7.
And what do you mean 24/7?
She lives with me. It's just right now she's with my mother. Cause I live with my parents.
And where's her mom?
Her mom, she has it like 2-3 times a week. She's here in San Antonio. She has her own apartment, so whenever she goes to work, she leaves her with my mom. And on her days off, my mom takes her to her.
All right, you have an issue with violence. So why do you keep hitting on people that you claim that you love?
Mm. I made a mistake.
No, you didn't make a mistake. You made a choice. When you put your hands on someone, it's not, oops, I mistakenly punch you in the face, or oops, I mistakenly choke you. You're making choices. So I'm trying to figure out what is your problem.
I was just very angry and I know I shouldn't have done it.
Yeah.
I know it was wrong.
So you have your daughter. How would you like it if she's in a relationship and somebody's putting their hands on her? How would you feel about that?
It
And for them to be saying, oh, it's a mistake. I was angry.
would break my heart. It would hurt me. I would probably be very upset.
Uh-huh. And so that's what you're doing. You're out here in the free world, putting your hands on someone else's daughter. And children learn how to behave in a relationship based upon what they see. So if your daughter sees you being abusive to her mother, then guess what? She's going to think, well, my dad tells me he loves my mom, or my dad says he loves his girlfriend, but he's always hitting on her. So that means if I'm in a relationship with a guy, if he hits on me, that will mean that he loves me. That's what you're putting out into your daughter's universe. Do you understand?
Yes, ma'am.
Are you employed?
Yes, ma'am.
What do you do?
I work at Wingstop.
Work where?
Wingstop.
All right. How far did you go in school?
All the way. 12.
All right. So what are you planning on doing with the rest of your life? I mean, we do need people to make wings, but I mean, is that your dream job?
No, ma'am.
Well, what are you planning on doing with the rest of your life?
I plan on getting my CDL.
All right. 6 years deferred adjudication, no contact with Kiana Richardson, restitution of $500, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person, regular random UAs. I'm going to order 400 hours of community service restitution. 100 hours of those will be waived once he completes parenting classes. And then another 100 hours will be waived if he completes a higher level of education or obtains some sort of trade school certificate. And then he will be responsible for the remaining 200 hours. There's going to be field visits one time per month for 4 months. The BIPP course, there's an affirmative finding of family violence. Take in consideration 2024 CR 6362, County Court Cause number 728, 729, 728, 793. And there's to be no unsupervised contact with minors, and that includes your child, until completion of parenting classes. And at least halfway completion of BIP course, the BIPP course. Probation, is there anything else he needs? Hi, is there anything else you need from the court to be successful?
No, Your Honor.
I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Do not put your hands on anybody in anger. Do you understand? If I could order you not to be in any relationship, I would. If there could be a letter on your chest to let women know that you have 2 assault family violence convictions in your life, I would have it embroidered in your chest. A for assaulter. You understand?
Yes, ma'am.
You had better start doing better and making better choices, and don't get in another relationship until you get an orchid with the flowers on it. Once those flowers fall off, wait until it blooms again. That will teach you patience. You understand?
Yes, ma'am.
Good luck to you.
Thank you so much, Your Honor.
You're welcome.
Thank you.
Jacqueline Alonzo. And this is no application, and this is the last case we're taking up. Court is calling 2022 CR 1590C, State of Texas versus Jacqueline Alonzo. Can I have parties announced for the record for the state? Defense.
Ms. Alonzo.
And are you Miss Alonzo?
Yes, ma'am.
Counsel, have you received all the discovery? Did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Miss Alonzo, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Alonzo, did you review the document entitled court admonishment with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with burglary of a building? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility
Yes,
and
Your
up to a
Honor.
$10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this agreement, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into agreement in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
Yes, you do.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Alonzo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes,
Are you a U.S. citizen?
yes,
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
yes,
According to the plea, punishment is to be assessed at 8 months in the state jail facility. There are no applications. They will take in consideration County Court Case Number 636311, Night Mag Number 764574. Did you understand that to be the plea? Defense, is that the plea?
It is.
State, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in all the appropriate places?
yes, Your Honor.
You understand by signing that you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence?
We were able to review it, no objection.
All right, did you review the waiver and consent to stipulations of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
All right, the court will sentence you to 8 months in the state jail facility, give you credit for any time served. Take in consideration County Court Cause Number 636311, Night Mag Number 764574. There's to be no contact with Armin, Armin Vasquez, and Abdallah, Abdalla, Abayomi, Abayomi, Ncince. Is there anything else with regards to sentencing?
Judge, only that, Ms. Alonso has taken a Silver Code Kitchen Basics class, has graduated from it while she was in jail, and was guaranteed through them a job in kitchen industry once she gets out. Additionally, she has signed up for GED classes, which she's already started, culinary class, art class, and computer class. The basis I'm telling you that is recommended.
Yes, all right, thank you so much. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. I appreciate the fact that you're doing things to better your life. It would be great if people would do that before they go into custody and get sentenced to time. But I'm glad that you're making corrections. All right, good luck to you.
Thank you, Your Honor.
Thank you.
This is your county board dismissal.
The parenting class. There's been a total credit of $150 for her fees and fines. And that's it, Judge.
All right, so she's pled to having been arrested and not report to probation after her arrest. What has she been arrested for?
May I address the court?
Yes.
Felon in possession. That case is still pre-indictment pending. It's independent of the resolution of this case.
All right, so she's on probation for felon in possession of a firearm. I know the state has not proceeded on the violation that you've just mentioned, the felon in possession of a firearm. But my concern is that she was arrested and she didn't report to probation after her arrest. So does she want to explain to the court why she did not do that?
Yes.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Monica Wade.
All right, why didn't you report
Well, when I initially got out of jail, I was not informed to go to report to the office.
I'm
but
sorry, you
that-
was not?
Informed to go report to my probation. But I contacted my attorney because my concern was I going to be issued an MTR immediately since they gave me the
No, but it's
possession?
in your conditions that when you're arrested, you need to contact probation and let them know. That's one of your conditions. Am I wrong in that?
No.
Okay, so you knew you were supposed to report after an arrest.
Okay, so then when I contacted the attorney, I asked him, I said, is there an MTR that was issued? Because if that was the case, I would like to see if I could do a satellite walkthrough. That way we have to go through the whole process of sitting in jail and doing all this, and all that.
Well, no, let's go back to the fact that you knew, because you had conditions of probation, that when you're arrested, and you just told me you knew when you're arrested and you're released, you have to report to probation. So what I'm hearing from you, and if I'm wrong, correct me.
Okay.
What I'm hearing from you is the reason why you didn't want to report to probation is because you didn't want to get arrested and have to wait at the jail. You wanted to do the easy way and see if you could do satellite. Am I correct in my interpretation?
And no, ma'am, when
All
I
right.
I did get the rules and the regulations on, I did not know until after the fact, when I was contacting my attorney about this MTR, is when I got my probation paperwork and I read it, and it did state that I had to report after. I was not aware of it before.
No, but they go over conditions with you, every condition.
I must have not heard it. I just didn't. So that's why I didn't go report immediately, but I had been reporting with no problem. I haven't given them any issues. On top of the classes, I'm on top of the money, I'm on top of.
I mean, I understand what you're saying, but you know what you're not on top of? And I don't know that the allegations, the state has waived and abandoned that in the allegations, but what you're not on top of is you were arrested for another offense.
Yes, ma'am.
And the number one thing when you're on probation is don't commit any new offenses, allegedly.
Correct.
And I'm not going to get into that new offense because the state is not proceeding on that. But you have to report.
Right.
And I'm inclined to follow your agreement, but I'm not inclined to have you walk out of here without doing your jail time. You understand?
Yes, ma'am.
All right. Is there anything else you wish to say?
No, ma'am.
All right. And what jail time are you all asking for?
The credit that she already has is how much? 25.
So, well, no, how much time is the state asking for her as a condition? Mhm. I'm not giving you credit for the 25 days. You're going to go into custody today. All right, the court will deny the motion. Alternate main conditions to include 25 days in the Bexar County Jail. Upon your release, you need to report to probation.
Yeah.
And state, you need to figure out what is going to be happening with that new case. How much time do y'all need to determine what you all want to do with that case or what's going to happen with it?
Unclear.
All right, and Mr. Callahan, are you on the new case?
Yes, Your Honor.
All right, Ms. Ferguson, her new case, let's set that in 60 days. And if you could give her a reset for that. Probation, is there anything else? All right, thank you. All right, it's gonna be September 10th, and if you'll get her a reset form.
Thank you, Judge.
No, it's just September 10th for the new.
I do have a blank order form if the court needs it.
Oh, no, I don't.
Okay.
Court is calling Night Mag number 7477790, State of Texas versus Johnny Luis Weschler III. Can I have parties announced for the record for the state,
Second for the state.
for the defense?
Ray Lopez for the defense.
And are you Mr. Weschler?
Yes, ma'am, I am.
All right, we're here on a defense's motion to modify bond conditions. State, have you had a chance to review the defendant's motion?
Yes, Your Honor.
All right, any objections?
If I properly understand council's motion, we did talk about this, of course. It's essentially three parts from partial to just tracking, waiving of a monthly fee, and then allowing him to reside in Pflugerville. Going in reverse order, I think council or the state has no objection to any type of transfer or anything with respect to Pflugerville. The state really, I told council really don't speak to any waiving of fees. And then to the first part, the state would feel more comfortable with partial, so we're opposed in that sense. I know they're asking for tracking, but given the offense report, again, at this time, the state feels that partial is more appropriate.
All right, so let's start with fees. With fees, I'll ask that fees be waived, but I can tell you what's going to end up happening. They're not going to waive his fees because it's a third-party contract. But yes. But I will ask them to defer or waive fees, and we'll see what they do.
Thank you,
There's
Judge.
supposed to be a monitoring device that is free. I have yet to see it, but they say there is a free one out there. All right, so the fees have been addressed. Now, with regards to the transfer, if he can still be monitored and transferred, the court will allow for transfer. So the next question is partial GPS versus tracking. State, why are you opposed to tracking?
I think given just the nature of the report, some of the aggressiveness asserted by the alleged aggressiveness exerted by the defendant on scene, and given some of the, the injuries with respect to the victim, that's why the state just feels more comfortable with tracking. We feel like it's a more robust measure of allowing this person to work and be a productive member of the community, but not necessarily just going to tracking normal.
All right, so defense, if he's given partial GPS, he would be allowed to work. So why are you requesting tracking?
Well, and we'll offer testimony, Your Honor. The partial GPS, he has, that's what he's on now. We'd like to switch to tracking. He's had it. It's affected his employment. It's affected his employment opportunities.
So
I could have him testify to that,
all right,
Judge.
would you raise your right
and-
hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, state your name for the record.
Johnny Wexler.
All right, you can lower your hand. All right, what is the issue with partial?
So with my employment, I've been in my job for 4 months. I've been very successful there. Started off as a dishwasher and I just got a promotion to a maintenance technician. There's been plenty of missed opportunities to where they want me to stay late.
Oh,
I
well, partial
was-
means that's partial for employment, so you can
Well-
stay late for employment.
Yes, ma'am. But as far as I'm concerned with my pretrial officer, I'm only allowed the allotted hours that I'm given, X amount of hours that I'm given.
Now,
if I
you have to, let me explain something to you. When it's partial for employment, the only thing that they're asking of you is they're asking for you to give them your work schedule. I understand sometimes when you work at restaurants, they'll give you one work schedule, then they'll ask you to stay late.
Yes.
You're allowed to stay late, but you'll need to send that information in to the pretrial service officers. All you have to do is leave a message. When you call and nobody answers, don't hang up. Leave a message that says your name, your SID number, or your case number, and let them know that you had to work late. And guess what? When they see your GPS signal, it will show that you're still at your work location. Now, if you tell them you have to work late and you're not at your work location, that's when there's going to be a problem. Every violation report comes to this court before somebody signs it, unless there's another judge sitting. But when they're not, they come to me and your counsel will tell you, usually, unless it's something egregious, I always ask for us to have a hearing so we can figure out what's going on.
Yes, ma'am. And there's been a couple of times where I have stayed like maybe an extra hour or hour and a half late. And they did end up calling me. I got a call from a tracking officer and he told me, you got to go home. I'm gonna give you 10 minutes, 15 minutes to do what you
No,
gotta do.
well,
and
I'm
then go
telling you what
home."
I'm telling you.
And
And I will send your pretrial services officer an email letting them know that partial for employment means that he's allowed to work. And what they need to do is look at the GPS and see if you are actually at the location where you're supposed to be working.
okay,
Now, there's a different matter if they have you working at restaurant A and you tell the tracking people, oh, I'm working late and I'm at restaurant A. And then your employer sends you to restaurant B.
yes, ma'am.
That's where issues come in.
Okay, I understand. So that was just the issue, just I was under the impression that I couldn't stay more than what outside of what I was
No,
approved for.
You just
So,
have to call them and let them know.
yes, ma'am.
And Judge, he has been having other issues with the, which has prompted a request for tracking. One, he's had other employment opportunities that have paid more, had a better payment, but because he's on partial tracking, once that comes up, he's not been able to have those opportunities. So
Well, do they not do it by Zoom and over the internet? Because now you can't even seek employment at any of the convenience stores. You have to go online to do it. So is it something where he has an interview set up?
it's something where he's already kind of in the interview process, and once they find out that he's on partial tracking, that just kind of stops their
Oh.
desire to want to hire him, which is why he's requesting tracking so he can have better opportunities. He's had opportunities where he could get paid twice as much as he's had now.
How is when they discover he's on GPS, that
Partial.
that he's on partial GPS? And so they're like, no, we won't hire you. We will prefer you to be on tracking. I don't understand that.
I think there'd be less involvement from their end with the GPS thing, is at least what they've conveyed to him. Whether that's true or not, we don't know, but that's what the business has been conveyed to him. It's like, well, it's too much trouble for us if you're on partial GPS.
It's too much trouble for them. They just have to provide him with a work schedule. And even if he wasn't, correct me if I'm wrong, if he wasn't on GPS, they still have to provide you with a work schedule. Like even for this job, I have to know what my work schedule is. And it's nothing for the government to say, hey, we're not going to give you your work schedule. I mean, everybody has to know what their work schedule is. Even when you're working at a fast food place, they may say, we're going to put the work schedule up for next week, at the end of this week. Everybody has a work schedule. Otherwise, how do we know when we're going to show up to work or we're supposed to be there?
If I may, Your Honor.
Sure.
There's a company called Airco, and they do like air conditioning and electrical and things, and plumbing. With those jobs, they do house like service calls. So you don't find out where you're going to that morning of, and it's a different house every day. And that was the issue that they had. Well, we can't really accommodate to giving you a heads up or a 24-hour notice in advance.
Mhm.
And that was the issue that they were having, is that it's too much for them to be able to want to comply with that.
No, I mean, they need to, even if you're doing AC and HVAC, which I don't understand why people are hiring people for AC and HVAC and people going into people's homes and not informing them of the people who are going into their homes. For example, the offense that you're charged with, I don't know anything about this. Everybody is presumed innocent.
Yes, ma'am.
However, it's an assault family second, which means you had a previous assault allegedly. And everybody is just letting people come into people's homes and nobody knows about anybody's background. And so let me just tell you why I'm going to keep the partial GPS as it is. Number one, I'm not saying anything is going to happen, but if nobody knows where you are, we're just doing tracking and you're just allowed to go wherever you want to go, and something happens, you know whose fault that is? It's yours, but also it's me, because what the heck was I thinking, right?
Yes, ma'am.
So the HVAC people, if they want you to be their employee, one, it's probably in your best interest to make sure they know about your history. And two, if they can only give you a 24-hour notice of where you're going to be, then again, all you have to do is call pretrial services, leave a message, because sometimes they don't answer, and say, I just been told for my employment, this is the address I need to go to. And you better be at that address.
Yes,
And then you can show your pretrial services officer the ticket saying that this is where I was sent for employment. Is that difficult? Am I?
no, ma'am.
All right.
But I do have other, if I may,
Mhm.
I have other things that I'd like to touch light on. As far as that, I just got enrolled into college as well.
I'm sorry, what?
I just got enrolled into college.
Mhm.
So I'm going to Texas State Technical College for industrial engineering. And I just would like to capitalize on the resources at campus if I'm able to go to like the library when I wanted.
That's what
study groups. or-
Google is for the,
I don't-
Google does the library.
Nothing like that. And I was
Cell
thinking,
phone?
I was just thinking of other resources as far as like study groups, going to the lab. They have labs there for me to go and physically like hands-on learning and stuff like that. So I was just thinking I could capitalize on those as well.
Okay. I appreciate when people are trying to improve themselves,
Yes, ma'am.
but I always wonder, why do people always try to improve themselves once they're put on GPS and they're restricted? Then it's like, oh, I want to spend time with my child and take them to baseball games. And before, they never took their child to baseball games.
ma'am.
So, I mean, you're on partial GPS for employment. How long have you been on GPS?
It's going on 6 months.
All right. So I'm not the one who placed you on GPS, but the nature of your case, you should be on GPS. So it's going to be partial GPS for employment. I'll ask that the fees be waived or deferred. And once you are actually in your classes, I'm sorry, could I have your order, counsel? Once you are actually in your classes at college, then the court will reconsider any other requests.
Yes, ma'am.
And who is your pretrial services officer?
Miss Ashley Graciano,
I'm sorry, who?
Ashley Graciano,
How do you spell the last name?
Graciano.
All right, if there's no objection, I will send Ashley Graciano an email as it relates to his work schedule.
I also wanted to see if I was able to go to church too. In light of the situation, it's really opened my eyes to really want to get closer, I guess, to God and my religion. And I would like to attend church.
All right, I understand what you're saying, but here's the thing, again. And I understand people are trying to improve themselves,
Yes, ma'am.
but people always want to do extra things when they're on GPS that they never wanted to do before, like church.
Yes, ma'am.
They have online church.
Yes, ma'am.
And I'm assuming you have a Bible?
I do.
There we go.
Understood. Yes, ma'am.
All right, is there anything else?
Nothing from the state.
No, that's from the defense, Your Honor.
All right, thank you.
Thank
And
you,
I will
Judge.
send the email to Ashley right now.
Thank you, Judge.
You're welcome. Date, am I correct?
That's what I understand.
Yes, Judge.
All right, so if you both would confer with Ms. Ferguson on a jury trial date and then let me know.
Okay, Judge.
All right,
Thank
thank
you,
you for dressing appropriately for court.
My pleasure. Your Honor, I had a question if I may. Is the possibility to appear via Zoom still an option or no longer an option?
No,
Yes,
because
ma'am.
you're gonna have your jury trial, so you can't do
No
it by
worries,
Zoom.
no worries.
All
I
right,
appreciate
thank you.
Thank you, Judge.
Y'all will confer with her and we'll take care of this.
Yes, Judge, thank you.
All right, who's here on Alvo Tucker?
Your Honor.
Are you all ready?
Yes, sir. Matter to bring up. What's the court?
Yes.
No. Judge,
Yes,
I have a matter to bring up. Mr. Tucker was here last week.
yes, I remember Mr. Tucker.
Placed back on probation. On Monday, we went to County Court 2, pled out on his 2 misdemeanors for time served. I don't know why he's in custody. And it's been, what, 4 days later and he's still in custody and that shouldn't be the
Oh,
case.
he's. Yes, you should talk with Miss. See, everyone, let me just explain something to y'all. Miss Abrams is not just here just to be here. She is an integral part of this system. So if you go speak to her, she'll be able to tell you. So if you'll have a seat, Mr. Tucker, yes.
ma'am.
All right.
Thank you, Michael. All right, who's here on John Swamley? Hello. Thank you for dressing appropriately for court.
Yes, ma'am. I just dressed up like this and then didn't even know I had court.
Oh, hey, well, I appreciate that. All right, so what is happening with this case?
Yes, Your Honor. Currently, he's at a lifetime recovery. He's gonna work on giving me some of that documentation
Okay.
so I can get over to the state. This is the very first court setting on this, Judge. I was looking into the discovery. When I requested it, it seems to have a number of files there. However, when I tried to download it, it indicated that the system was down due to maintenance on the e-discovery system.
I'd like for you, would you like to admit that into evidence?
If I may, Judge, let me just stick around. Stick around. But
No, I appreciate that.
yes, Judge, things happen, but yeah, I would like some time to review the evidence and have access to the system, Judge. for-
All right, so Mr. Smalley, how long are you in, how many more days do you have in lifetime recovery?
Well, it's complicated. They told me it was a 45-day minimum, but then the counselors there, put it 60. And then if you follow the program correctly, then they'll drop it down back to that 45.
Here's the thing. My motto is let the professionals tell you when you're ready, because lifetime recovery is a good place to be.
I love it there. It's amazing. Great
Awesome.
people, great food, everything. I love it. Brings up my spirits.
All right, so just stay with lifetime recovery. I'm gonna give you a reset, but I'm expecting you to remain at lifetime recovery. You understand?
Yes, ma'am.
All right, so counsel, how much time are you requesting?
Just the standard 30-day, Your Honor, please.
All right, and state, is there any CPS records involved in this?
I believe I've made a request for them already. It's kind of embedded in there.
Okay,
We'll double check because it's a little hard to see again what's online.
all right, Ms. Ferguson, if we can recall this in 30 days, please?
Yes, ma'am. I can do August 8th.
Yes, Your Honor, that would work for defense.
All right, we'll be back on August 8th. Once you sign the reset form, you are excused.
Thank you, ma'am.
All right,
Have
you're
a blessed day.
Oh, thank you, you too.
Renee Munoz.
Judge, if I can ask, at September 3rd, is that okay with the court?
Let me see. What date?
September 3rd?
Yes,
Thank you, Judge.
you're welcome. Oh, and counsel, just one moment.
Yes, Judge.
State on Darwin Gomez, if you all could do an acknowledgement of discovery, the court doesn't have one in its file.
Okay.
All right, thank you.
Yes, Your Honor.
August 8th, response.
What date is it?
August 26th.
All right. If you want to text Johnny to come back. And what page is Darwin on? Gomez? All right, thank you. Augustine Adam?
Morning, Judge.
Morning.
Marissa Giovenco, Giovenco. You got it, okay. Judge, when you're ready, sorry.
All right, yes.
Good morning, Judge. Mr. Adam, I did get notice of being appointed to.
Everyone, please whisper.
I did get notice of being appointed to the motion to revoke.
Mhm.
There are two additional cases. One is not a new number one. One was prior to being put on probation, and one is a new number one. I did not get notice with Odyssey of being appointed to those two, so I learned that I was appointed to those two and that they existed this morning. I have been able to look at the case that is not a new number one. However, the state has not been able to bring down the new number one that's alleged in the amended that was filed this morning. I know nothing about it other than the charge. I'm asking if we can have more time, Judge, if we can have a reset.
All right, Ms. Ferguson, on this case, and it is Augustine Adam. Recall it in 3 weeks.
Thank you so much. Judge.
You're welcome.
I appreciate it.
What date?
I think it's August 1st.
All right, we'll be back on August 1st.
Thank you.
And state, if you'll make sure she has the discovery. Thank you. Ms. Abrams, Augustine Adam has been recalled for August 1st.
And I went ahead and let the complaint, or I informed our advocate to speak to the complainant for the Kamara exchange. I just want to let you know that I'm
All
on.
right, thank you.
You're very welcome.
All right, and we have a new probation officer.
Yes,
Hi, come forward. Everyone, we have a new probation officer and you all, and notice I say you all have been completely ignoring Miss Abrams. What message are you sending to the new probation officer? So welcome
Thank
to the
you.
187th, and attorneys are usually better than that.
A couple of them came over. I'll give credit where credit is due.
All right, you guys, she's giving you some credit. All right, welcome.
Thank you.
My name is Johnny, but I'm better known as Handsome.
There it is.
Johnny,
Yes, ma'am.
you didn't get your reset for your client.
Oh, that's right. Thank you.
Who's here on are you already on Alvo Tucker?
Already did that, Judge.
No. You're asking why he was in custody. Has that issue been solved?
It has.
Ms. Abrams, thank you for informing the defense counsel of this. You had the information, but nobody wanted to receive it.
Judge, we do still have some outstanding issues with Mr. Tucker's case though. So
Mr. Tucker, come on down. This is about you.
So Judge, as an original condition of probation, Mr. Tucker was mandated to get a GPS through work release.
Yes.
Waive fees and such. So during the install for the GPS, or we thought would happen, there was new information that was provided. Apparently, the 2 county court cases that he had pled to already was still shown in the system as active.
Okay.
So that's one issue that we're having. And then there's another issue to where there is an out of county warrant in Victoria for Mr. Tucker, which with all of that, the GPS cannot be installed.
All right, so what we'll do, because I'm sure they want him released to go to Victoria County, we will release him so he can go to Victoria County. And when he comes back, he'll be placed on GPS.
Yes, Judge.
All right, so we're gonna go on the record.
And Judge,
Yes.
just to be clear, and I've asked Mr. De Leon to kind of check into those other 2 county court cases
Okay.
to make sure that all that's cleared up.
Judge, I blame the Odyssey system. It
You know-
stinks.
Well, you should have the sign that Renee Munoz had that it said systems down.
Okay.
All right, we're gonna go on the record in 2023 CR 4059, State of Texas versus Alvo Tucker for the defense.
Michael DeLeon for Mr. Tucker.
And are you Mr. Tucker?
Yes, ma'am.
All right, so you were here previously on a motion to revoke. The court had ordered that you be placed on GPS. And my understanding is Victoria County would like to have words with him.
Yes.
And so therefore the GPS, they're not able to place him on GPS while that is open. So what the court is going to do is the court is going to lift the GPS order to allow him to go to Victoria. Once the issues in Victoria are settled, he will be back in Bexar County and he will be placed on GPS. Do you understand?
Yes, ma'am.
And do I need to, we can go off the record. Let me remind you of something. You are looking at 10 years in prison if a motion to revoke is filed. Do you understand?
Yes, ma'am.
So from here on out, everything you need to do,
It's gonna be spot
you
on.
need to ask yourself, is this something that could potentially result in me being revoked? If the answer is yes, don't do it. If the answer is maybe, don't do it.
You're absolutely correct, 100%.
All right, and every decision you make, you should ask yourselves, am I being put at risk of maybe going to prison for 10 years? And then if the answer is yes, and you still want to do it, you need to ask yourself, is this worth 10 years? I always tell people, you're not allowed to smoke marijuana on probation. Those are not my rules. That's the government's rule. That's the law. And you need to ask yourself, smoking this marijuana, that would be nice, but is it worth potentially going to prison for 10 years?
Not by a long shot.
Drinking alcohol, you're not allowed to drink alcohol while you're on probation. Doesn't matter if it's at your house, at a cookout, whatever, you're not allowed. That's the legislature. Those are their rules. If people want to change the rules for people to be allowed to drink alcohol on probation, write your congressman. But you need to ask yourself, is this alcohol worth me going to prison potentially for 10 years? And then people at the prison will be, what are you here for? And of course, they want to blame the judge, Michael. They'll say, the judge just sent me to prison for drinking alcohol. They don't tell the rest of the story.
Yes.
All right, if there's anything that you need, and you feel as though probation is not addressing it, you can always come back to court.
Well,
And when you're released from Victoria, then you need to pick up the phone and call your probation officer.
yes, ma'am.
All right, anything else?
The one from Victoria is for probation. It's
All right, here's the thing, your attorney will speak to you about that.
okay.
I have no jurisdiction in Victoria.
Wish you did.
I do not.
You can't control Victoria County, Judge?
I can't even
You
control,
are really good.
I can't even control the parish in Louisiana.
Thank you, Judge. We
All right,
appreciate
thank
it.
you.
Thank you, ma'am.
All right, thank you. Just one moment, let me write this down. All right. All right, have Johnny come back and I'll talk to him. Thank you. Mario Miranda. Hello, yes, hi. Where's Mr. Miranda? Hi.
Michael J. Sawyer, SAW,
All right. And this is for sentencing?
It's a PSI, Your Honor, but I had a request, but
Sure. What's your request?
in looking at the PSI, I noticed that there was a report that I need. District Attorney's offered to get it for me. I have any time to review that with my client.
What is this report?
So,
It is a police report, Your Honor.
so counsel, if I understand counsel's request correctly, and we did speak before approaching, if I understand correctly, counsel believes there's an inconsistency in listing in the PSI versus the underlying police report in the stipulations. So I let counsel know, we're more than happy to print that out for him here in the courtroom. And if I'm flowing through the chain here, counsel would still request some time to kind of go through and make some comparative analysis.
All right, so I'm gonna have you,
Very short amount of time, Your Honor, just maybe the next court setting.
the next court setting will be Monday.
Monday would be sufficient, Your Honor.
All right, how long is this police report though?
I do not know, but I will print it out.
All right, let's do this. Print out the report. Let me see how long it is and then I'll consider your continuance.
Thank you.
All right, thank you. Ross Kuko? Is he in custody?
Yes, ma'am. He's in custody.
All right, Deputy Laura, can you bring Mr. Kuko out? Mhm. Mhm. Well, they need to send an attorney unless the paralegal has a license.
Yes, thank you.
All right, I'll take this up in a moment. Meredith,
Yes, Judge.
you have coup code?
Yes, Judge. My jury's out. We were closing this morning for the 144, so that's why I'm late.
Oh, okay,
And Your Honor, may I briefly approach?
yes.
Miranda, we typically only have one report in the, or a police report in the or in the file, but we had two, so here it is. Well, papers. And again, that's the underlying police report in general.
Okay, so, Mr. Sawyer, I don't understand. If there's a discrepancy in the PSI report and what's in the police report, if you just tell the court what the discrepancy is, the court will take that under advisement.
The discrepancy is the same witness gave two different stories.
Mhm.
One there just seeing the policeman making that report and came to the police department later and then changed that story.
Okay,
And I need time just to sit down, explain to my client. I have to repeat myself over and over to him. I speak very loud to him. It does not go as easy as talking to the average client. That's why I was asking for a couple of days, just so you thoroughly understand the changes that are being out there.
well, but. Mr.
And I don't think I've
Sawyer,
ever requested a reset of PSI.
Mr. Sawyer, I'm gonna have to deny that. This case has been around for a long time. All right,
We'll take it from there.
all right, thank
Okay,
you.
thank you.
Still let you hold on. You're very welcome.
Joshua Tejas, come forward.
All the way to the arrow.
Hello, hi. Thank you for dressing appropriately for court.
I appreciate it.
State on this case, it's a criminal trial division. His attorney has filed a motion to revoke. She says she has food poisoning. I'm sorry, not a
was like,
motion to revoke.
I was like, all right.
She's
I was like,
she's in
my
agreement,
lady?
right? Yeah, yeah. No, I'm so sorry. It is like very hot in here. Am I the only one or is something wrong today?
I'm in a,
I already called.
I'm in a full suit too. I'm busting a sweat.
Okay, thank you so much. It is very hot in here. All right, so what we're gonna do is we're gonna recall this, Ms. Ferguson. We can recall this probation either for the 15th or the 16th. All right, 15th or 16th. All right, you're gonna come back on July 15th and we'll hear this motion.
Gotcha. Sounds good.
All right,
Have a good
thank
day,
you.
Your Honor.
All right, once you sign the reset form, you're excused.
We'll call you.
Oh my gosh, I can't tell, it is extremely hot.
I did call Judge.
It's getting to the point where the robe may have to. Yeah, it may have to be removed and I'll just be here in a dress.
On that one is still contested, right?
Yes. Who is here on Joe Isaac Yanes?
Good morning, and it is warm in here.
Oh, thank you so much. I'm telling you, the robe is this close.
Okay.
The other courtroom I used to be in, I would tell everybody, I'm like, I apologize, I'm not in a robe, it's just too hot.
Yeah, it's a little toasty, you know.
Yeah. All right, so discovery and additional charges.
So just to catch the court up, which I'm sure the court already knows, Mr. Jimenez had actually been hired on a couple of these cases and then got off.
Mhm.
And so Norma appointed me to those and we wanted to make sure that all the discovery was uploaded to my bar number, which it was.
Okay.
So I have no problem signing a discovery acknowledgement today for all the cases. I'm actually actively conferring. There you are. And so we just need a plea deadline, but honestly, Judge, we may ask Norma to put us sooner than that.
All right, Ms. Ferguson, on Yanes, I need a plea deadline date and I'll give you 30 days.
That'd be fine. And then I'll if something pops, I'll let you know.
Okay. All right, August 8th.
That sounds great.
And councils, if you all can do the acknowledgement of discovery. Do you have any questions, Mr. Yanes?
No, man.
All right, we're going to be back on August 8th. On that date, you need to let the court know whether or not you've reached an agreement. If for some reason your attorney wants you brought back sooner, they will let the court know.
Yes, ma'am.
All right, thank you.
I'll get you with Zoom. Okay, okay. You can.
Yes. Who's here on Miguel Perez Narano? Good morning, and you're on this side, counsel.
Good morning.
Good morning.
Yes,
sir. We were reviewing the file, Your Honor, and we found two DVDs from the police department that were not included in discovery. So I spoke with the state and they're gonna try to get me that either physical or uploaded.
All right, Ms. Ferguson, this will be your both parties' last date for discovery. Ms. Ferguson, if you recall this for 30 days, and at that time, you all need to be prepared to sign an acknowledgement of discovery. If there's an issue with discovery, then states you'll need to subpoena witnesses. All right. Yes, what date? All right, we'll be back on August 8th for discovery.
Thank you.
Is there anything else?
That would be it, sir.
All right, and counsel, have you addressed the immigration issues?
Yes, sir.
All right, thank you.
Thank you very much.
All right, once he signs the reset form, he's excused.
Okay, so.
And thank you for dressing appropriately for court. Hi, always good to see you.
Your Honor, may I ask you to
Oh, yes.
for a signature?
Thank you, Your Honor. Sure.
May I be excused?
Yes, thank you.
There it is. Okay, good.
Oh, just 1 second, I'm writing.
Oh, yeah, sure.
Jonathan Morales.
Here, Your Honor.
Hi, and where's your client?
Unfortunately, he hasn't reported in today.
All right. Do you know, is he on a commercial bond? Have you talked with the bondsman?
I haven't spoken to the bondsman, Your Honor.
I'm sorry?
I haven't spoken to the bondsman, but it's a commercial bond.
All right. Do you want to see if the bondsman knows where your client is?
I can try.
All right. If you'll do that and then come back and I'll take it up.
Okay.
All right. Thank you. Annabelle Vela.
I'm learning from y'all. Morning, Judge.
Good morning. How are you doing?
I'm doing good. For once, I'm not hot. For once, I'm like, usually I'm sweating up a storm.
So you all ready to proceed?
Yes, Judge.
All right, everyone, we're on the record. Court is calling 2023 CR 8486, State of Texas versus Annabelle Vela. Can I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Paul Acevedo for the defense.
And are you Miss Vela?
Yes, ma'am.
Did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes.
Are you the same Annabelle Marie Vela who was placed on community supervision in 2023 CR 8486 for the offense of driving while intoxicated with a child under 15 on October 23rd, on October 30th, 2023 for a term of 3 years? Is that you?
Yes, ma'am.
State?
Violated condition number 12, on or about the third day of June 2024 in Atascosa County, Texas. The defendant, Annabelle Marie Vela, operated a vehicle without a valid Texas driver's license in violation of condition number 12.
How do you plead to that? True or not true?
True.
Your Honor, the state was all the violations.
Any objections?
We have no objections, Your Honor.
Did you understand by pleading true to violation of condition number 12, the court could find it true, grant the motion, and sentence you to 2 years in the state jail facility
Yes, ma'am.
and a $500 fine? All right, we're on the record. Don't approach the clerk while we're on the record. All right, don't approach while we're on the record. All right. Knowing that, do you still wish to plead true to violation of condition number 12? Court will find violation of condition number 12 true. Is there a proposed agreement?
Yes, Your Honor, it's the alternate amend for the defendant to take a defensive driving course and to continue on probation, sorry.
All right, why is she driving without a license?
Would you like for me to address it or would you like to hear it straight from her?
Sure. Could you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Annabelle Vela.
Judge, she is a little nervous, so just
Oh.
just a little patient.
Yeah, don't be nervous. Just tell me the truth. Why are you driving without a license?
So I was with my friends. I know I wasn't supposed to be driving. She told me she wasn't feeling well. A couple years ago, she had fractured her spine and her tailbone, and it often causes her to have back problems where she can't walk or sit too long. So she asked me, is like, hey, like we're a couple minutes away, a couple miles away. Can you just finish out the drive, get us there, and then my boyfriend will drive us back, and then I can Uber you home from there. So I was like, I'm really not supposed to, but you know, you're not feeling well and we can't just sit on the side of the road. So I'll just finish out the drive and then that's it.
Did somebody have a phone to call the boyfriend?
She did, but he was at work and he was about to be off. So I don't know what, I didn't think of it at the time. So I just agreed. I was like, okay, I'll get us there. But then after that, I can't do no more because, you know, I can't be driving and she's aware that I can't be driving, but I'll help you out and I'll just get us there and that's it. And it was not far. I hadn't been driving long before the cop pulled us over.
Well, see, the issue about it's not far is neither here nor there. You're not supposed to be driving, period.
Yes, ma'am.
And then you're driving and you don't have a license. And then you're driving and you're not insured. So if there were an accident and you're driving without a license and you hit somebody, do you think anybody would care that, oh, it was just 2 blocks away?
No, ma'am.
Judge, if I may, on her behalf, I don't think she gave the full story, the way it really worked out. This friend that she's talking about is not just a friend, it's somebody that she's met recently and she's met her through her employment. This friend is her supervisor. She was still on the clock at work and the supervisor was off the clock at this point. The supervisor returned to work to give her a ride home. And that's when this transpired. When she was actually getting ready to give her a ride home and then she felt ill.
I had an opportunity to run her name through DPS. She is eligible for her driver's license. And we've talked about making arrangements to get her driver's license back. No occupational license is needed at this point. It's just a matter of getting caught up on some fees and DPS fees at that, Your Honor. And paying the endorsement for the driver's license. She did self-report this. It was filed as a Class C misdemeanor because it's a driving while license invalid as opposed to driving while license suspended. And she called me. I told her, bring it in. I'll help her take care of it. She reported to probation a day or two later. And she self-reported it to probation at that point. She herself is up to date on all of the conditions of probation. She's has taken some steps in life because of this probation that has made her a little bit more responsible. Not a little bit, a lot more responsible. Financially, she's making better decisions. On a personal level, she's making better decisions. And on the course here, she's trying to make some good decisions. I asked her what has happened, and, what's causing you to do these things. And she said, to be honest, the judge spoke to me the last time and she talked to me about accountability, and I'm, trying to be accountable. Thus the self-reporting and so forth. I don't want to speak out of line, Judge, but I do believe if she would have never said anything, chances are the ticket Class C would have been taken care of and nothing would have ever happened. And of course, she did self-report and let the probation department know that she did receive the ticket.
And state, what are you requesting?
I was again, was the defensive driving judge, at least from what I can tell, she is eligible for license. And the fact that she is.
And probation, what are you requesting?
Defensive driving judge.
All right, the court will deny the motion. Alternate amend conditions to include defensive driving. You're not supposed to drive without a license, period. I understand now that your attorney, we can go off the record. Your attorney explained that the person with you was your supervisor, so I can understand feeling pressure because it's your supervisor and you could end up getting fired. But you are not allowed to violate conditions of probation. You're not allowed to drive without a license. You understand? All right, good luck to you.
Judge, can I just address one more issue that I feel like we need to address and just to have a clear understanding? She does not own a vehicle right now.
Mhm.
She is using the handheld device. She has the scram device.
Mhm.
So she hasn't had any violations and so forth. However, when she does apply for a driver's license, she has to pay for a ignition interlock endorsement, but she doesn't have a vehicle, so she will have a license that says ignition interlock, but if she is driving again, she's gonna have a scram device. I don't know how that would work with DPS.
I don't know. What would end up happening is if she has a driver's license and she has her vehicle, just come back and we'll address it.
Okay, thank you, Judge.
Oh. Yes. Thank you for dressing appropriately for court.
Paul, Paul. Call me Joseph.
Are you already on Jonathan Morales? Are you already on Ross Kuko?
Almost, Judge.
All right, thank you.
I'm in the check.
All right, Brenda Ortiz Navarro. Yes. Are you all ready or no?
Judge, I'm asking for a Spanish speaking attorney.
All right, just give us a moment. All right, is there an attorney in here who speaks Spanish fluently? Look at Joseph shaking his head. No. Adrian. Oh,
Más o menos.
all right, whatever that means. Okay.
I can talk enough today until you get an interpreter, Judge. Then I-
Oh, okay. Renee, you fluent?
There we go.
All right. Norma? That's Renee Munoz. All right, thank you.
Who's the new attorney?
Renee Munoz.
You know. All right.
So what,
All right, and I had to teach myself.
so Adrian,
Yes,
what were you saying in
more or
Spanish?
less.
Oh, more or less. See, I'm used to people doing that.
Just
Yeah.
little charades. I know enough out of necessity, and but it's situations, but.
Yes. Yes. Ah, thank you.
Yeah.
All right, Ivan Pacheco. Where's Mr. Pacheco?
Lots of funds. That's the, which is the state, you know. I think you're being completely reasonable. Can't do better than the other man.
Yes. All right, so where are we on?
This one, this is sort of unique.
Everyone, please whisper.
This individual is about to be, well, hopefully
Sentence.
about to be sentenced to federal time. And there's a range that I've been disclosed, but also has done some things that we were looking.
All right, no. So when will he be sentenced? Do we know?
We don't know. We do know the PSI is in and he is reviewing it with his attorney on the federal case. And there's my understanding is there's a big block of defendants and they're not all going to be set at the same time, but no date has been set yet.
All right, so this is what we'll do. We'll recall this for the, we'll recall it for the end of August.
And that's fine, Judge. I mean, I think we'll be able to handle it either way.
All right, and if you all do something before that time, you all can always come back in sooner. Thank you for addressing it appropriately for court. Ms. Ferguson, what date? End of August? All
Yes,
right,
that works.
we'll be back on August 27th.
Thank you, Judge.
You have a good day.
All right, thank you so much. Once you sign the reset form, you're excused. Are you all ready on Mario Miranda? All right,
Your Honor, may I just have 2 more minutes?
okay,
That's it. That's all I want.
all
I
right.
promise. Judge, I really appreciate it. Thank you for that. I had
All
to
right,
just-
you ready?
I had to square something up and I've done that.
All right, thank you. All right, Mario Miranda.
Speaker. Is there anything to say in this sector? Okay.
All right, and Mr. Miranda, if that has a seat on it, if you would like to be seated, that's fine. If that will help you.
I think I can stand.
All right.
Just a little bit of cane.
All right. Court is calling 2023 CR 0683, State of Texas versus Mario Miranda. Can I have parties announced for the record for the state,
That done for the state?
for the defense?
Michael J. Sawyer.
Are you Mr. Miranda?
Yes, ma'am.
You entered a plea of no contest on May 17th. According to the plea bargain agreement, punishment is to be assessed at 5 years in the prison. The state opposes your application. There's an affirmative finding of family violence. There's to be no contact with the complainants. Have both parties had a chance to review the PSI report, state,
Yes, Your Honor.
defense?
Yes, Your Honor.
Any objections to the PSI report, defense?
Just wanted discrepancy in an account, and we have a copy of that report that was filled out by SAPD Patrolman Torres.
Mhm.
State has given a copy of that report this morning. And I believe that, does the court have a copy of that in their possession as part of the PSI?
Yes, I have a copy of the PSI. If you'll tell me, direct me to what page?
Well, I'm looking at it. Judge, look at that report.
No, no worries.
So John, simply give the court the report, the state will not object.
All right, I have a copy of, the police report.
Police report, yes, ma'am.
All right, and this is defense exhibit number 1, the defense, you're not offering into evidence, you're just asking the court to review?
That is correct, and I have a couple of questions about it, and I said that I believe the court can review it and
Yes.
see the discrepancy. Certainly. Ms. Miranda or me?
Well, I guess me.
All right, court has had a chance to review.
And I just want to point to the court. Nick Miranda, who was there, told Officer Torres, when the first policeman was seen in that report, that he disarmed the defendant in the bedroom at the very onset. It's in the report.
All right.
That's all.
All right, any evidence, state or defense?
No evidence from the state.
Nothing further from the defense. I think most information the court needs is contained in that PSI. We have reviewed it. It is accurate. Look at his prior criminal record here, California, Medina County. It's true and correct in our opinion.
All right. All right, then, state you're opposed,
Yes, Your Honor.
and if you would like to present your argument.
Yes, Your Honor. So we'll present, we thank you for the opportunity for just brief argument. And this is an individual, Your Honor, wherein, lack of accountability seems to be kind of first and foremost here. You have their partner, which, said he, friends have told me he's looking for me. I believe he's gonna kill me. He's a very violent man. You have her son saying he's the type of man that, again, will come and find us. He's threatened to kill me. No care, no remorse, no sympathy, no empathy. And even in the defendant's version of events, there's just a complete lack of accountability.
Well,
All of this is based on lies. I don't want probation, but I don't want to go to prison. So not only is there no accepting of consequences, there's no actual acceptance of what's underlying. And again, I think you have two complainants wherein the version of events, as is noted in the stipulations that the court has reviewed, and it is noted in the PSI, it started over something pretty benign. And I think that's what bothers the state the most. This was over a disagreement involving a taco. And then after that discussion, defendant has his version, but through pre-trials and all the discovery given to defense and the police reports and the other evidence that was disclosed over the defense, a pretty clear version of events is that if the young man had not taken this individual's gun away, 2 people might be dead. And so given their complete lack of disregard or complete lack of regard and a disregard for human life and for consequences, that is the, in summation, the state's opposition to probation in this case, Your Honor.
All right, so here's my question. And if you could raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Mario Miranda.
All right. So, are you currently living in Bear County?
Yes, ma'am.
Who do
I
you
have
live
my
with?
home now. Pardon me, ma'am?
Who lives with you?
Just me and my girlfriend and my oldest son.
All right. So how do you know the people who were involved in this?
How do I know? She was my ex-wife and divorced in '93. And that was her other son that she had while we were married. Wasn't my son. And well, she had the audacity to go have that son under my insurance, under my hospital from the VA.
All right, so here's the thing, mother's baby, father's baby, but that's all on you because you allowed that to happen. All you had to do was a DNA test. So we're past the point of you're trying to seek sympathy for the court because you've been paying for a son who's biologically not your son. I'm trying to figure out who were all the people who were in the home and were you all living together when this happened?
Yes, ma'am. I have my 2 sons and her son and her, and nobody was paying except for me.
Nobody was what?
Paying, for nothing.
All right, then you should have put people out. They're all adults.
Yep, exactly. I should have put them out.
All
But
right.
I had compassion for especially her, because she was renting an apartment with my oldest son, and they lost the apartment, they got evicted. And she was supposed to have heart surgery. She hasn't had heart surgery since then. It was all a lie, I think.
All right, and what is this about a taco?
Well,
State
the
says
whole
this
thing
is,
happened, that we were having a yard sale. And she was there with her sister and she said, there's nothing for breakfast. I said, well, okay, fine, I'll go to HEB and get this stuff. But she said, well, I'll cook for all of us. Well, it turned out she cooked for everybody else except for me. And I said, thank you for the taco. That's all I said. And then she started at me, and then all of a sudden I got her son on me. And he got up like he threatened me and said, you owe this and that, and vulgar language, I'll do this to you right now. And he's a weightlifter in MMA. See? And that's what I was afraid of, that he was gonna get me. So I went to my room. I got my gun and I was gonna leave the house. I was gonna holster my weapon.
Mhm.
and I was gonna leave. But I still had a license to carry and everything, and I was able to defend myself that way. I couldn't fight with a young man like that. And I was gonna leave the house, but then as I was going out, when after the weapon was taken away from me and everything, then he assaulted me in the kitchen. And when the officers came, she right away, my ex-wife, right? She right away started saying, he was pointing a gun at me and my son. And it was only him. I mean, my other son was there. And he's the one that took my weapon away from me. And that was taking it out of the pouch. And as soon as I got out of the pouch, he had the gun in his hand. So there was no assault there. And she lied, I mean, for the longest time. She's been trying to get my money out of the VA also, saying that she's my common law wife. And in all the report that she makes, my husband. I'm not her husband. You know, they worked her back in 93.
Okay. All right. Any questions?
Would it surprise you that the version of events, again, this was all disclosed to counsel, that the complainant, the young man, said that the actual version of account is that you got home angry and that you were yelling at Maria and they said, lay off her. And you said, well, don't tell me nothing because I'll put a bullet in your head if you don't shut up.
Oh,
Does it surprise you that that's the account that was given to the state?
That's a question. He's asking a question. He wants you to answer it.
The question is, does that surprise you that that's the version or the account that was given to the state?
I didn't know about that.
Okay.
That's why I didn't know nothing about that.
My second question is, if you were so intent on leaving, right, so the door to the outside where the garage sale was happening,
Yes.
was right next to the kitchen where the stove was. But
Right.
instead, you chose to walk all the way down the hall past 3 bedrooms to the last one on the left to then retrieve your gun. Isn't that correct?
No. The gun was in the last bedroom. That was my bedroom.
Correct. The gun is in the last bedroom on the left. Yes or no?
Yes, he went there. Yes.
Right.
He followed me from the dining area to the room, and so did she. And then my other son, middle son, Nick, he's the one when I was taking out the weapon that he took it away from me then.
So if Nick hadn't taken the gun away from you after you threatened 2 people multiple times to shoot them in the head, do you think they
No.
would be dead had he not taken the gun away?
No, sir. I never made any kind of threat.
No further questions, Your Honor.
All right. So I will tell you both, this is what I'm reading in the police report, and this is a witness. And it's witness 1, and it's on page 2 of the police report. It says on July 16th, I called witness 1 for a statement and conducted it over the phone. Witness 1 said he initially heard arguing between AP and victim 2. His brother, victim 1, then intervened and began arguing with the AP. And your client, of course, is AP. Witness said that victim 1 told AP that he needed to be beat up for the way he was acting. Witness 1 believes this sounded like a threat to AP. AP then went into his bedroom. Witness 1 heard victim 1 yell that AP was going to get his gun. Witness 1 did not hear AP verbally threaten victim 1 or victim 2. Witness 1 said he saw AP take his gun out and point it sideways. Witness 1 quickly pulled AP's arm up in the air and got the gun from his hand. Witness 1 did not see AP point the gun directly at victim 1 and 2. Witness said he then went to go hide the gun in a box. Witness 1 stated while he was hiding the gun, another argument started in the kitchen. Witness 1 said he walked in the kitchen and saw victim 1 on top of AP1. On top of AP. Witness separated them and asked for police to be called. So that's what witness 1 is saying. Is there anything else from either side?
No, Your Honor.
Nothing from the state, Your Honor.
All right, so this is this is what the court is gonna note. Because this case, is it a difficult case for the court to make a decision on? Yes. But what I have, the person I have standing before me, based upon the PSI report and everything else, it shows that he is a veteran. And then let's see, where did here we are. On page 6 of the PSI report, he is on no less than 26 medications. And he has several mental health issues. He has PTSD, neuropathy in both legs, osteoarthritis, knee replacement, hypertension, type 2 diabetes, benign prostate, hypertrophy, gastroesophageal reflux disease, hyperlipidemia, hematochezia, tuberculosis of the colon, hearing loss, erectile dysfunction, cardiac murmur, anemia, microcytosis, bilateral cataracts, cherry angioma, polymyalgia, rheumatica, hemorrhoids, depressive disorder, psychotic disorder. And then they have him on 26 medications. And what I'm reviewing in the police report, I understand that the charge is aggravated assault with a deadly weapon. I understand that the defendant has entered a plea to aggravated assault with a deadly weapon based upon what witness 1 is saying and the other witnesses. I believe the truth is somewhere in the middle because the defendant has his truth. The complainants in the case have their truth. And usually, sometimes it's best to get truth from witnesses because they technically may not have a dog in the fight. But I do understand in this case, some witnesses were what he says, his children. Some witnesses was her child. I understand all of this. So the way I see my job is 1, what is the appropriate sentence for him? And also protect the community, and protecting the community means protecting the people who are the complainants in this case.
And Your Honor, may I speak just
Yes.
very briefly? I believe in terms of what was just spoken about even today, there seems to be kind of two
Camps?
No, camps, absolutely, and almost 2 events within one day wherein the allegation of the aggravated assault via pointing the weapon and then the kind of scuffle after the fact.
Yes.
And I just so that, it was, I think, more clear on the state side, and I should have done this sooner, but even the eyewitness, so the 2 complainants and eyewitness, quote, he stated he observed S1 retrieve the gun and point it towards the victims. And then later in that paragraph, he said he did not, quote, I did not observe any physical assault. So even the eyewitness, there's no question, again, in terms of the state's perspective on the pointing, but absolutely cannot corroborate with respect to eyewitness testimony, the latter scuffle, if you will.
Oh, no, and I understand all of this started over taco.
Yes,
Um,
and they would fight like that all the
Stop.
time. I'm sorry, ma'am.
all right, so my understanding is like the individual children who are involved are adults. The other complainant is his ex-wife. They don't have any young children where there needs to be any sort of custody arrangements. There's no need for them to have any contact. I can give him deferred adjudication, but he is not allowed to have possession of any weapons, period. You
Your Honor,
say,
if I may, I had a long discussion with my client about that. He agrees. Any condition imposed by the court, he will follow it.
Yes, ma'am.
all right, so I'm telling you, and I look at his criminal history. And this is his criminal history, this case. I don't, and of course he has a previous, driving while intoxicated. So his history is driving while intoxicated in this case. and he's done probation for the driving while intoxicated previously, and that probation was terminated. And I'm sorry, he had a theft of service, which is with a check, where he wrote a check and didn't pay. So he has a theft of service, DWI in this case. And in this case, what I'm viewing is, number one, all of these grown adults who are living in the home, in his home, who shouldn't even be there. Get a job, go live somewhere else if you don't like the rules. I understand this was an issue over a taco. You have the issue of the taco compounded by their having a garage sale, and garage sales never go the way people expect it. They always think they're going to make a lot of money. You pay for your permit and then you make maybe $2. So we have that going on. And then we have the PTSD with him. And then we have all of these medical issues. I just don't think this case is necessarily a prison case. And honestly, I don't think he would survive in prison. And when I say survive in prison, I mean because of all of his medical issues, and that would cost the government more money to place him at the prison. All right, this is what the court is going to do. There's going to be an affirmative finding of family violence. The court is going to sentence you to 5 years deferred adjudication. There's to be no contact with the following. There's to be no contact with Jonathan Garcia and Maria Garcia. The court notes that you're receiving your benefits from the VA and also receiving other benefits. You're going to need to provide that to probation. So, Ms. Abrams, I don't believe he's able to work based upon all of his medical conditions. So he'll just provide proof of VA benefits to probation within 30 days. There's to be regular reporting by Zoom or in person. There's to be regular UAs, although Ms. Abrams, I think that UA is going to be filled with positive based upon all the medications. You're going to need to provide probation with a list of your medications. You understand?
I already have them.
All right,
I've
no,
done all-
no, no. Listen to me.
Well, they-
Provide them with a list of your medications. Right. And let me see. All right, there's going to be outpatient treatment with the VA. There's to be weekly sober meetings with the VA until further notice. I'm not going to order community service hours. I don't believe he's able to complete community service hours. Is there any objection?
Not at all.
None.
All right, there is going to be field visits, random, one time per month until further notice. And probation, if you could let the officers make sure that there are no weapons in that home. Probation, is there anything else? Yes. You're not allowed to possess any weapons. Do you understand?
Yes, ma'am.
All right. Is there anything else you need from the court?
No, ma'am. I don't think so.
All right. Did you review the document entitled Trial Court Certification of oh, I'm sorry. There's also an affirmative finding of deadly weapon. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it? Did you review that and sign that?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, You do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Miranda, here's the thing. If you cannot get along with people, you shouldn't let people live with you. And you're not to have any contact with them. If you end up having contact with them, a motion to revoke is going to be filed and you're looking at 20 years in the prison. Do you understand?
Yes, ma'am.
All right, do you have any questions about my instructions to you or what you need to do?
Them showing up in my home.
Call the police.
Okay. I understand.
All right, you'll need to call the police if they show up. You understand?
Yes, ma'am.
All right, thank you.
All right, thank you.
On behalf of my client, and thank the court for the consideration today.
All right, thank you.
All right,
Have a
thank you,
good one.
ma'am.
Oh, and Mr. Sawyer, how's your wife?
Very much better, thank you.
All right, awesome.
Making my life a lot easier.
All right, have a good one.
Thank you for asking.
Thank you, Ron.
I know that. I'm so much here. Thank you so much.
Yes, hi. Yes,
This is back on the Jonathan Morales case.
yes.
He is actually on the PR bond. So I called pretrial services. I did get a number. I left a message. I left my cell number
Okay.
and everything, so.
All right, we'll go on the record. All right, can I have a prosecutor, please? The court is calling 2024 CR 5806, State of Texas versus Jonathan Morales. Can I have parties announced for the record for the state,
Jason Gary.
for the defense?
David Clare.
This hearing was called at 9 a.m. It is now 11:14 a.m. and your client has not appeared for court. Counsel, have you had any contact with your client?
It's been several months, Your Honor.
All right, and just one moment. Deputy Laura is making an announcement and state this is a PR bond.
Yeah.
It's taken her a while. Maybe he's outside. All right, Deputy, did you make an announcement for Jonathan Morales?
Yes, Your Honor, I did. He is now in the hallway.
All right, state.
State's requesting the judge's warrant, Your Honor.
All right, judge's warrant will be granted. If your client makes an appearance, the court will reconsider.
Yes, sir.
All right, thank you.
Thank you. Have a sweet.
Yes.
Thank you.
So Attorney Wood.
David Cuellar. David Cuellar. Yeah, David. He's in custody.
All right, that's judge's warrant. All right, are the parties ready on Kuko?
Yes, Jason just stepped out.
All right.
Prosecutor. I was
All
doing
right,
that.
thank you. Kobe Leach. Who's the attorney for Kobe Leach?
Judge, that's Mr. Jason.
All right, just have a seat. We'll come back to you.
He's here, Judge.
Ah, okay. No problem. All right, are you all ready on Kobe Leach? Court is calling 2020 CR 11344, State of Texas versus Kobe Leach. Could I-
Leach.
If you come down, could I have parties announced for the record for the state? Defense?
The attorney of record is Joanne De Hoyos. Joseph Stateson standing in. Mr. Leach, will you give this judge permission for me to do this in place of Ms. De Hoyos?
Yes.
All right, Mr. Leach, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Kobe Neal Leach who was placed on community supervision in 2020 CR 11344 for the offense of burglary of a habitation on February 2nd, 2021 for a term of 4 years? Is that you?
Yes, Your Honor.
All right, state.
Violating condition number 1, on or about the 26th day of September 2021 in Comal County, Texas. The defendant, Kobe Neal Leach, committed the offense of possession of a controlled substance less than a gram in violation of condition.
How do you plead that to that, true or not true?
No contest.
If that had explained, it's not guilty or no contest, if it's true or not true.
True.
All right. State, are you proceeding on the remaining allegations?
No, Your Honor, we're waiving the remaining.
Any objection?
No objection, Your Honor.
All right, did you understand by pleading true to violation of condition number one, the court could find it true, grant the motion, and sentence you to 5 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number one?
Yes, Your Honor.
Court will find violation of condition number one true. Is there a proposed agreement?
Yes, Your Honor, it's to revoke and to reform the judgment for 3 years, please.
All right. Is that the agreement, counsel?
It is, Your Honor.
And Mr. Leach, are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will grant the motion, sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Gabriella Rauhuff, Rauhuff, Maddox, Maddox Sanchez, Micah, Micah Jenkins, and 301 Windcrest Drive, located in Windcrest 78239. All right, my understanding that your client was previously determined to be incompetent.
That is correct, Your Honor. However, he was restored to competency at Carruthers Court recently, and he's currently on medication. He's stabilized. If I could put something else on the record, Your Honor.
Yes, please.
He does have pending Comal County cases open. There is a hold on him. I had explained to him that we are not resolving his Comal County cases with this plea. His attorney has to get any type of jail time credit for Comal County, but I checked with the clerk, Jennifer, and she had calculated 1,001 days. So that's 1,001 days credits. Additionally to that, he did do residential lifetime recovery. I know that it's not lockdown facility for lifetime, but he did complete lifetime recovery inpatient. He did suffer from mental health illness. He's been medicated for quite a while.
All
We're
right,
wondering
so-
if you could give him lifetime recovery credit.
Well, has he been in, because I see that he was previously incompetent. Did they send him to the state hospital?
Since October of 2023 till June 12th of 2024, he's been in the state hospital.
All right, I'll give him credit for any time that he's been in the state hospital, but not for lifetime recovery.
Okay, thank you, Judge. Nothing further.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement. Because this is a, I'm sorry, because this is a plea bargaining agreement, because I followed your plea bargaining agreement. And because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. So make sure that you stay in contact with your doctors when you're released. Do you understand?
Yes, Your Honor. I was seeing if I can be taken off compelled.
You'll have to address that with your attorney.
Right.
All right,
I
thank
had-
you.
I mentioned, yeah, right. I'll talk with him, Judge.
All right, thank you.
Oh, all on this.
Brenda, East Nevada, and we have the interpreter here as well. It's just going to be an announcement.
Judge, may I approach real quick?
Yes.
Judge, on, I've got a Paul Luna agreed, time served, not time served, but we have a deal. Thing is, I understand you have a trial this afternoon. I've got an appointment at noon.
Oh, work out your paperwork. We'll see if we get to it.
We did the paperwork already, but
Okay, I'm gonna call it. All right, thank you.
as soon as possible, that'd be great.
I'm sorry, what? Sure. Something robotic. All right, who's here on call? Fuller?
Right here, Your Honor. Would you like Mr. Fuller present?
Yes. All right, where are we on this case?
Judge, the state made an offer. We're still speaking to some of the witnesses, so we're still thinking about it, but we have made an offer as of today.
All right. Thank you for dressing appropriately for court, Mr. Fuller. All right, Ms. Ferguson, on this case, can I have a 30-day reset for a plea deadline date? All right, you'll be back on August 8th. On August 8th, you need to let the court know whether or not you're accepting the state's offer. All right, once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome.
Yes, hi.
There you go. Judge, I'm sorry, may I be excused? There's been a question in my case. which
Sure.
carries out. I'll be
Okay.
back. Thank you.
Number, what page is Fuller on? All right, thank you.
Do you have no feed areas?
Yes, I'm getting to it.
Okay, I just want to make sure. I can find it.
James Brandyberg.
Hi.
Mr. Brandyberg, come down. All right, today is plea deadline date.
Yes, Your Honor.
Is there a request for a jury trial?
There is going to be, Your Honor.
All
Yes, Your
right,
Honor.
Ms. Ferguson, I need a jury trial date on Brandyberg, and you all will need to file an acknowledgement of discovery today.
Yes, Your Honor.
All right, if you all confer with her on a date, then come back.
Wonderful. Thank you.
You're welcome. Darius Murphy.
You can go ahead. I'll let you know the court date. I don't know.
All right, so where are we on discovery on Mr. Murphy?
Defense is in receipt of discovery, Judge. In conferring with the state, they've offered a pretrial diversion. We're gonna go ahead and submit this to the 4th DA's office, Judge.
All right,
If this could be reset for status of pretrial diversion.
all right. Norma, on Mr. Murphy, I need a PTD setting.
I can do it on stage.
All right, we'll be back on August 8th.
Okay, yes, Your Honor, August 8th.
And Your Honor.
Yes.
On Brandyberg, I just wanted the court to be aware, we had signed on 6/20, both parties. So thankfully we have, and no additional discovery has come in.
All right, sign, what, you decided on what?
I apologize. I'm being a little unclear today in so many ways. Council and I were able to sign a discovery acknowledgement on 6/12.
Okay, I don't have it in the file.
We will redo it, no worries.
All right.
And Judge, we scheduled September 9th for Brandyberg.
All right, thank you. All right, thank you. Just have a seat. Brenda Ortiz Navarro.
RENE, Renee, last name Munoz, MUNOZ. Oh, no problem. Oh, it's okay. It's always better to be sure.
Oh, hi, morning.
How are you?
All right, how are you doing?
Good, thank you.
All right, so we're here today. Where are we on Discovery Council?
Your Honor, that is something I need to check in on. It's my understanding, today, earlier she had previous counsel.
Yes.
I myself, Renee Munoz, have agreed to take on the case as her new appointed counsel. So this is an individual judge that has potential immigration consequences. So I'm gonna need to reach out to an immigration attorney to see about potential consequences of a potential guilty plea. And also check into the discovery judge if I may.
All right, so what we'll do, because I know there's going to take some time with immigration, we'll recall this back in 45 days. Is that potentially enough time, counsel?
Yes, Your Honor.
All right, Ms. Ferguson, I need a 45-day reset on Brenda Ortiz.
And as a side note, Judge, I know that she's currently remanded without bond. Upon me filing a request to set bond, would the court entertain that motion?
Yes.
Thank you, Judge.
Judge, I can do August 22nd. No, 26th. I'm sorry.
All right, we'll be back on August 26th. And Ms. Ortiz, your attorney will file a motion and the court will consider the bond. Okay. All right, is there anything else?
Nothing further, Judge.
No, thank you very much.
All right, thank you. De nada.
This courtroom hearing took a serious turn when a man stood before the judge on a family violence assault charge. The judge made sure he understood exactly what he was facing. The charge was a third-degree felony, carrying a possible 2 to 10 years in prison and up to a $10,000 fine. He entered a no-contest plea and accepted deferred adjudication. But the judge wasn't satisfied with simply accepting his plea. She wanted to know why he continued putting his hands on people he claimed to love. His explanation was that he had been angry and had made a mistake. The judge immediately pushed back. She told him this wasn't simply a mistake, it was a choice. She then made the situation personal, asking how he would feel if someone treated his own 3-year-old daughter the same way. The judge warned him that children learn what relationships are supposed to look like by watching their parents. If his daughter grew up seeing violence presented alongside the words "I love you," she could eventually believe that abuse is simply part of love. The court ultimately gave him 6 years of deferred adjudication,